We know oral argument is mostly theater, justices leveraging the arguing attorneys to make points they want their fellow justices to hear from someone else. Let's break down what happened with Adam White, senior fellow at the American Enterprise Institute. Adam, you are a regular now on EWTN. Thank you for coming back. Justices Thomas and Justice Gorsuch joined other justices who thought the doctors might not even have standing or the right to sue in this case. What does that tell us about the potential outcome right from the start?
Well, I think oral argument sent a pretty clear sign that there is a high likelihood the court will not actually decide the substantive issue at hand, namely, was the FDA's changes to its authorization of the abortion pill lawful or not. The Supreme Court and all other federal courts, they are constitutionally empowered to hear what's called cases and controversies, which means that the plaintiffs bringing cases have to have standing. They have to show to the judge's satisfaction that the plaintiffs and their organization suffer an actual injury caused by the defendant, which can be remedied by the court. And throughout oral argument in this case, the justices, almost across the board, had real questions about whether the doctors in this case could sufficiently prove that they would actually be affected by this FDA policy. The court did delve a little bit into the FDA's analysis, but by and large, this case has become a broader case about how and when people can challenge decisions of administrative agencies.
That's right. And so this role that the doctor plays in abortion complications, it did come up many times. It was one of the main arguments and explanations that attorney Aaron Hawley had. Do those arguments make any difference at all?
Well, the arguments certainly make logical sense. The two doctors in particular who filed affidavits in support of their standing told the courts that they are at a significant risk to be summoned into an emergency situation, say an emergency room, where they would have to complete a process of a medical abortion right there in the emergency room without real time to express their own religious-based objections to participating in this. And of course, in theory, that makes sense. And I don't think any of the justices really disputed that that's possible in theory. But to prove standing, plaintiffs normally have to show that their possible injuries are not just theoretical, but there is a real concrete probability that they could actually be affected by these policies. And even a number of the conservative justices, including Justice Amy Coney Barrett, seemed very hesitant to conclude that the declarations, the affidavits filed in this case were sufficient to really convince the judges that these doctors are at a substantial risk of having to assist in medical abortions.
Now, what kind of remedy would those doctors then have if they don't have some kind of a conscientious objection, a federal claim? Do they have some kind of a tort, some kind of a criminal, or any other kind of remedy that they could bring to the courts?
Well, you know, as I listened to oral argument and I listened to it again, really to think through this exact question, it seems to me that the upshot of this case, if the court holds that these doctors do not have standing to challenge this FDA policy, it could have ripple effects through the medical profession more generally. Because if the justices, in effect, punt these questions to the emergency context, where there is very little time for doctors to make their objections, and in a context where it might be very hard for a doctor to make objections, I think there will be a push by doctors and by those who support them for hospitals and emergency rooms to create an infrastructure ahead of time so that doctors' religious objections can be known, that emergency rooms and others can plan in advance for this, so that in the end, the doctors are not required to make or withhold their objections in the most horrible emergency circumstances. And so if the court does not decide this case, I think there'll be a real push for hospitals and doctors to start planning in advance for this.
Right. Well, let's go back to the FDA then. FDA surveillance of adverse effects did come up, and with Danko Labs as well. Is there any way that this case could affect how the FDA looks at drug approvals and reporting more specifically?
Well, that's a great question. And you're right that this did come up a little bit during oral argument, but it wasn't fully aired. None of the substantive issues were fully aired. But just as this case has come to stand for something more on questions of who can sue, who has standing to sue, even if the court doesn't reach the merits, I do think that the FDA's actions in 2016 and especially in 2020, and including the 2016 decision to roll back reporting requirements in 2016 to roll back reporting requirements for non-fatal complications, it does call into question the rigor of the FDA's analysis in this. And while judges, including the justices here, are always reluctant to micromanage policy judgments, especially where agencies might claim some kind of expertise, cases like this are a stark reminder that oftentimes agencies do begin with a policy objective in mind and reframe their analysis accordingly. And that's a much broader question and problem in modern administration.
Now, nationwide or universal injunctions also came up. What was Justice Gorsuch's objection to this? Might others try to convince him otherwise?
Justice Gorsuch pushed back slightly at the plaintiffs here, asking why, even if these doctors have the right to sue here, why the remedy has to go beyond these doctors in particular, say giving them some kind of exemption personally, and going so far as to rescind the FDA decisions altogether. And that's an issue that goes well beyond this case. Questions of district court judges from one administration to the next, issuing decisions that purport to shut down a federal policy nationwide just from one federal district courthouse. And many justices, including Justice Thomas, have raised concerns about this over the years. Justice Gorsuch might see this case as an opportunity, maybe in a concurring opinion, to reiterate concerns about these nationwide or universal injunctions. Justice Gorsuch did something very similar, by the way, on the standing question. Even while acknowledging that it's unclear and maybe doubtful that these plaintiffs do have standing in this case, Justice Gorsuch pointed out that in other areas of law, including when individuals want to raise Establishment Clause challenges to policies they don't like, the Supreme Court in decades past was more lenient to those plaintiffs. That might not cut in favor of the plaintiffs in this case, but Justice Gorsuch and others might use this case to point out that maybe standing needs to be made more uniform across all areas of constitutional law.
Well, it sure sounds like there are a lot of tricky issues that didn't really get to the pro-life issues at hand, but that there are other ways that these doctors and mothers and children might be protected in the future. Thank you so much, Adam.
Thank you.